right, take two. Over to you, Adam.
Awesome. Thank you. So look, what I was trying to say before when you couldn't hear me was I'm notorious for not sticking to the script. And that's because I prefer to answer your questions. I prefer to talk to you about what you want to know rather than run you through what's written into these slides if that's not of interest. I think it's interesting, but it might not be the most important thing to you today. So yeah, please ask any questions you want. So just by way of background very quickly, I'm not going to, it says Futurity on the screen. That's the company I work for. I'm going to try not to talk about Futurity. I'm going to talk about bonds in general. So bonds in general, not government bonds, but investment bonds, they're simply a structure, another investment structure, very similar to superannuation in that people contribute money to the structure. They choose how they want it invested when it's in the structure. And while that money is invested, the structure is paying tax on any investment earnings, as opposed to the individual paying tax at their personal marginal rate. Now, the other important thing is, like superannuation, is that tax rate is a concessional tax rate. So it normally sits somewhere between 20 and 30%. So historically, bonds were used by high income earners that had maxed out superannuation or just wanted another structure that they could invest in, and they didn't want to pay 47% tax. They prefer to pay tax somewhere between 20 and 30%. So that's how they started. But over time, more and more people have started looking at them as an estate planning, I won't say solution, because they're not the solution, but they can be part of the estate plan. And something that Tara and I spoke about is how a bond is sometimes used for grandchildren, right? Where you might want to invest a small amount of money and you don't necessarily need a testamentary trust because you're looking at $50,000 or $100,000. Conversely, there are situations where large estate payments have come through and everyone's sitting back wishing that we had a testamentary trust, but one wasn't established. Okay, well, we might use the bond as an alternative because we didn't have the testamentary trust set up in time. So that's where we'll head to today. But again, yeah, if you want to ask questions as we go, please do. This first slide's a bit of a general overview. I'm not going to talk to everything on there, but I'll talk to a few things and I'll try and give you real life examples. As with any presentation, like we have case studies produced by marketing, but I'll give you real life examples from advisors and lawyers that I've been working closely with over the last 5 years. So if you look at the inner circle, that green, all those green dots, these are features that are available on all investment bonds. And there's quite a few of us in the market now. They're becoming more and more popular. So more and more people are sort of making them available. So this is common across all of them. And if you move from left to right, the first one is the will-like estate planning, which is a relatively straightforward one. So one of the attractive features about bonds is it's actually a structure that sits outside of the estate. But the bond owner can nominate beneficiaries so that upon death, the proceeds transfer directly to those beneficiaries and bypass the estate. So often used where you've got blended families. I've got a really interesting one, which I'll talk about later, where we had a grandparent that had 2 adult children and I think 3 grandchildren. And she was essentially trying to bypass the adult children and make sure that the money went to the grandchildren when they turned 25. So that's I mean, similar to why a lot of people might want to use a testamentary trust. The next one is straightforward. People can just put a lump sum of money in, or they can set up regular savings plan. The third one in future activated transfer, that's just our name for it. But that's essentially saying we're going to set this structure up so that it automatically transfers to someone at a given point in time in the future, right? So I'll tell a bit of a story just to make sense of this one. It's a very popular feature that I actually don't like, all right? And to explain, I think it's a very popular feature because there's a nice narrative that goes with it. So a lot of grandparents, for example, might have a new grandchild and they like the idea of putting $5,000 or $50,000 aside. And when this grandchild turns 18 or 21, that money automatically transfers to the grandchild and there's no capital gains tax implications for anyone. So it's a nice, simple narrative. But if you walk into my grandparents' house in East Keilor down in Melbourne, above the fireplace, there's a photo of me when I was about 4, my older brother and my 2 older cousins. Now, if you look at the kids in that photo, you think, oh, they're sweet kids. Of course, I want to invest some money for them when they become young adults. But fast forward 40 years, I know what I was like when I was 18 and 21. I was a good kid, but I was having a very good time. So if I was to receive $50,000 at the age of 18 or 21, it's going to be spent on things that my grandparents probably don't want it spent on. I've got a slide later that shows what grandparents want to help with, and it certainly wasn't what I was doing when I was 21 years of age. But then the two cousins I spoke about, unfortunately, they went down a path that they can no longer come back from, and I'll leave it at that. But it's fair to say you certainly would not want them receiving any money for any reason whatsoever. So a future activated transfer, it's a nice narrative, but I think why set these things in motion when so much can change over the period of 14 to 18 years? Now, in saying that, there are absolutely reasons where you might use it. And this is another example that Tara and I were brainstorming yesterday. We had a really unfortunate situation come out of Townsville where a husband and wife had separated, and the wife had taken the children, and she wasn't allowing the husband to see the kids. I'm paraphrasing here, so please don't get upset if it sounds a bit crass. But it wasn't a good situation, and the husband ended up taking his own life. And he took his life because he wasn't able to see his kids. Now, he hadn't updated any of his estate. So all of his wealth transferred to the spouse. So they were separated, but not on paper, is my understanding. So all of the money transferred to the spouse, but his mum then stepped in and said, I just don't think that's appropriate. Like, if you think about the reasons why he's taken his life, I don't believe this money should be going to her. It went to court, and court agreed. And they basically said, all right, we need at least $500,000 of that money invested for these children. And it must transfer, or the children must take ownership of it when they're 18 years of age. So that was as an example of where we had estate proceeds, we didn't have a testamentary trust, but we had a court order essentially that said this money must be invested to the kids and must transfer to them when they turn 18. And I thought that was a very good example of where you could use the future activated transfer, because you can structure this investment to do exactly what the courts wanted to do. So hopefully that makes sense. And then just moving across the next few, they're relatively straightforward. A lot of people don't know any money within a bond is protected from creditors. So self-employed people quite like these structures. There are avenues for tax-free access. So if you think about the superannuation analogy I provided before, if you put money into superannuation, you can normally get your money out of superannuation tax-free if you meet a condition of release. And the two most common conditions of release are retirement or death. With traditional bonds, it's kind of the same. If you die, someone can receive that money tax-free, or normally after a period of 10 years, you can receive it tax-free. So normally a little bit sooner than the superannuation conditions of release, but there's ways to put your money in, pay a concessional rate of tax, and be able to access that money after 10 years tax-free. And the final one is I've already touched on. Basically, it's a structure where you put money into the structure and tax is paid on those earnings in the structure. It isn't distributed to the owner and taxed in their personal name. So the example there, again, one Tara and I have sort of been speaking about a little bit. If you remember at the start, I said bonds are normally taxed at somewhere between 20 and 30%. So historically, people have used them for people on the sort of highest marginal tax rate. But we have more people actually using them where it's not about the tax arbitrage. It's just about the fact they want to reduce their reportable taxable income. And the example I had was a husband and a wife. They'd separated. The husband had care of the children, which probably tells you a little bit about the situation. And the husband really didn't want to invest money. It sounds silly, but he was frightened that if he invested money, well, that's going to, any investment returns are going to end up on his tax return, which means a portion of those investment returns are then going to continue to fund his former wife's lifestyle that he didn't agree with. So he wanted to invest for his kids and he wanted to invest for himself, but he didn't want to invest for her chosen lifestyle. It's the cleanest way I can tell that story. But what they realized is, well, if they put that money into a bond, well, then that money is taxed inside the bond. And after a period of time, he can make tax-free withdrawals, which don't end up on his tax return. So it was a way he could invest money for himself. He could invest money for his children without fear of supplementing a lifestyle that he didn't think was appropriate for the kids to be exposed to. So tax paid investing is more than just paying tax at a low rate. There's a whole range of reasons why people want tax paid inside the structure and not in their own personal name. Is everyone relatively comfortable with what I've covered so far?
Thank you, Adam. That's such a good summary. And we have had a question come through from Neil. Hi, Neil. Good to see you again. So Neil, he's hitting you with the hard questions straight up. So I'm glad you told me that you had your legislation references loaded, locked and loaded. So Neil it has a question about the will-like estate planning component and from death.
Oh, Neil Dennis. I know Neil well.
Yeah. I'll read out the question for everybody and you can read it too, Adam. So from death, does the income generated result in accepted trust income, or is it eligible for accepted trust income treatment thereof?
I'm smiling because that's an incredibly good question, and I must thank Neil for asking it. Thank you very, very much. So I might need to, you might need to give me another 2 or 3 minutes to sort of set it up, and then my response to that question will make a lot more sense. No, it's a very good question, Neil. Thank you. So what we've been doing so far is we've been talking about traditional investment bonds, where you invest your money and you wait a period of 10 years and withdraw it tax paid. Now, there's a subset of investment bonds called scholarship plans. I joke that scholarship's too hard to spell, so we all just call them education bonds. Now, we provide one, Australian Unity provide ones. There's a third provider called Foresters that provides one, and there's another provider that's going to launch one pretty soon. So there's a few more of us coming onto the market. And essentially, an education bond will pretty much do everything an investment bond does, but it's got a bit of extra flexibility and it's got some additional tax benefits. Now, without leaning too much into it, because this is not a product presentation, one of the key differences is with education bonds, when you contribute money, it sits in what's called a capital account, and any investment earnings it generates sits in a separate earnings account. So when a bond owner logs in, they can clearly see, well, what have I put in? So almost like an offset account, and what is it generated, right? And the generated part will be, well, these are your investment earnings after that tax was paid on them. So it's sort of like contributions and net earnings. Now that allows the bond owner to actually go, well, do I want to wait 10 years and treat it like a normal investment bond and pull from both accounts at the same time? Or do I just want to isolate my contributions and pull that out for any purpose whatsoever? Now, I've just done that recently. My wife just turned 40 and we went on a family holiday to New Zealand, and I just pulled $5,000 out of my contributions account tax-free. So think about it like superannuation, right? You would probably put more money into superannuation if you knew whatever you put in, you could withdraw tax-free pre-retirement. That's what you can do with an education bond, right? The reason they're called education bonds is if you withdraw those earnings and you use them for an education purpose, then when they come out, they actually come out with a 30% tax credit. So a simple example would be if I pull $10,000 of earnings from an education bond and I say I'm using that for education, which might be fees, it might be uniforms, it might be sporting equipment. It's quite broad what education expenses are. Even though 10,000 comes out, the balance is only going to reduce by 7,000, because what will happen is you'll tell us you want 10,000, but you'll get 7,000 of your earnings plus a $3,000 tax credit, because these are your earnings after tax. But if you pull those earnings out to fund education, then the tax that was previously paid is reimbursed. So you can turn your tax paid earnings into tax-free earnings. Now that sounds really good on paper, but the problem is at the end of the year, we'll then send a letter to the bond owner that says, look, that $10,000 you received, that's actually assessable income for the beneficiary, right? So in simple terms, I've got a 9-year-old, a 7-year-old, and a 5-year-old. If I pull $10,000 out for their education, I'm creating it's a good tax outcome for me, right? But it's a horrible tax outcome for them, because at the end of the year, they've received $10,000 of assessable income. So what that means is when people are using education bonds in the traditional sense, they tend to use those earnings when the kids have turned 18 and have access to the adult tax-free threshold. So it might be used for TAFE, it might be used for university, or it might be used to reimburse historic education expenses, right? Now, there's a lot in that, but then just moving into the realm of the estate planning lawyers. Oh, I just saw Damien Eales is in here as well. Thank you, Damien. Where this works really well in the world of estate planning, and I'll go to the Tax Act. If I do this and I put this up here. So this is a section of the Tax Act that some of you will be familiar with. And
so that's not sharing on our.
No, it's not sharing. Let me just what I'll do is
you might have to
turn it off.
Screen.
I'll screen share again. Yeah. Okay, so hopefully this works now.
We're still seeing the PowerPoint.
Yeah, it's just hopefully uploading for us in a moment.
Yeah. Okay, beautiful.
You can see it now, or doesn't want to play ball. Hang on, let me just try something else.
Okay.
It doesn't seem to want to let me do the screen share.
Oh,
That's okay.
Are you sharing the window or the?
It's not letting me share anything, but that's okay. What I'll do is
we're still seeing your PowerPoint.
Yeah.
So you might have to stop sharing.
What I can do then is we've got a snippet in the PowerPoint.
Okay.
Here.
Yes. Thanks, Colleen. The suspense of the tax legislation.
Yeah, it is. It's very exciting. Now, I must thank someone in this audience. I won't name names, but I must thank someone in this audience for actually helping me understand this better than I originally did about 3 years ago. So there's a number of reasons why a minor is taxed as an adult, right? And the one that most people in this audience would be aware of is if they're receiving proceeds of a testamentary trust. So it's referred to as accepted income, and it's Section 102AE of the Income Tax Assessment Act. And essentially what it's saying is if a minor is a direct beneficiary of an estate and that money is invested for the minor, then the minor is taxed as though they're an adult, which is how a testamentary trust works, because you have a death benefit and the estate is saying, well, this money is to be held in trust for the benefit of this child, which means that child now receives accepted income status and is taxed as an adult. So that same thing can apply with a bond where you have a estate payment and a child is nominated as the beneficiary of the estate, but there is no testamentary trust. So what you can do instead is you could put that money into an education bond, and then you can distribute the earnings to the child and they'll be taxed as an adult, even if they're under age 18. So where that's used is in those scenarios where you might have a grandparent that wants to leave $50,000 to a grandchild or a great-grandchild, and you might not want to set up a testamentary trust for $50,000. So you could set it up so that upon death, this money is put into an education bond and it will work like a testamentary trust, and that the money is protected. It can transfer to the child at a future date, but the investment earnings can be distributed to the child and they'll be taxed as an adult, very similar to a testamentary trust. Now, there is thank you for sharing the link, Tara. Now, there's another one under that which talks about the ability for an estate benefit to be transferred to a minor. Now, the first section of the Tax Act reads as though anyone that receives a death benefit can transfer that to a child, and as long as they transfer it within 3 years, the child will be taxed as an adult. However, if you scroll further down, I think it's subsection 10, and anyone that knows the Tax Act without looking at it can correct me on this, it starts talking about intestacy laws. And essentially what that means is, yes, you can transfer it and the child would be taxed as an adult, provided there's the intestacy alignment there. And so the example I would give is if I died without a will, the courts would step in and go, right, well, we're going to give this amount of money to your spouse and the balance is going to be divided equally among your 3 kids. in simple terms. Now, if I died and I did have a will and I said I want 100% of it to go to my spouse, she could actually transfer that to the children because of the intestacy relationship that we just spoke about. But in summary, going all the way back to Neil's original question, is it works best when the estate directly names the beneficiary. But there are occasions where money can go to an adult and it can be transferred to a child if there is an intestacy relationship. But intestacy laws in each state are quite different. Queensland seems to be a lot easier to get your head around than New South Wales. But they are the sort of things that we help financial advisors sort of wrap their head around when clients come in and say, hey, I've received an inheritance, or grandparents have passed away and the kids have been named as beneficiaries. What do I do with it?
And so, Adam, just on that intestacy point, some jurisdictions like Queensland and I mean, potentially Queensland might end up changing, is on the cards, but currently Queensland and in Western Australia, where you have got a deceased who is in a relationship also with children, then part of the estate will pass to the surviving spouse, but the children also are entitled on intestacy. But in other states like New South Wales and Victoria, the children are not entitled in intestacy where there's a surviving spouse. So I know, like in the post-death testamentary trust concept, we actually don't really, because of this requirement that the amount that can be treated as being eligible for accepted assessable or accepted trust income is equivalent to what that child would have received on intestacy. In like New South Wales and Victoria, they actually have a $0 entitlement on intestacy where there's a surviving spouse. And so the strategy is a lot less useful in those jurisdictions. So do we have the same, you would have the same limitation under 102 AE, I guess?
That is my understanding. Now, I make it very clear that I work for a product provider, but I go out of my way to make sure I'm up to date as much as I possibly can with legislative changes. And that's why I know some of the people that are dialing into this, because I've actually bounced and brainstormed a couple of questions with them over time. So to those who are in the audience, you know who I'm referring to, and I appreciate your assistance. But yeah, where the strategies are really clean is where you have a child directly nominated as the beneficiary of an estate. In Queensland currently, my understanding of the intestacy laws there are some clean examples of when you can transfer it, but you go to places like New South Wales and it's a bit trickier because you've got notional estate laws to deal with. But if my understanding is correct, the way the intestacy laws work in New South Wales is you can potentially transfer it to the child of a previous marriage, but you cannot. I mean, you can transfer it to anyone, but if you want them to get accepted income status, they would need to be the child of a previous relationship, not your current relationship. So it's why we stress to everyone, each state has their own individual intestacy laws, and it's why we often work quite closely with accountants, financial advisors, and the estate planning specialists to make sure we're getting it right. Which might lead to another, probably a simple example of one that we had where we were working with a financial advisor and an estate planning specialist. It was a scenario where it was actually a financial advisor had taken their own life, and they were they'd separated from their spouse, but they were still caring for their spouse. But basically what they'd said in their will is, we want this money, the majority of this money, to be set aside for the kids, but we still want to provide for some living expenses for my spouse. And so that was an example where they didn't have a testamentary trust, but because the children were explicitly named, they could set up a bond. Those children would be taxed as adults, so they can distribute the $18,200 to them without creating a tax event. But what we were also able to do was make periodic withdrawals from the initial contribution to make sure that the spouse was taken care of and she could sort of pay for groceries, pay for rent, and all that sort of thing. So dialing all this back, where it works best is when you have estate proceeds where a child is specifically nominated as a beneficiary. And then there's another one in the Tax Act, which sits just a little bit higher, which talks about basically proceeds from a life insurance policy. And that was something I didn't touch on, is bonds are actually insurance policies. And that's where the asset protection and the non-estate asset sort of benefits come from. But if you think about it, if a bond is a life insurance policy and your bond owner dies, well, the moment your bond owner dies, you now have a death benefit. So all of your nominated beneficiaries now get taxed as adults. And that's why we're seeing more and more grandparents and great-grandparents using bonds to transfer wealth. So are there any other questions before I kind of go into that strategy in more detail, actually?
I actually have a question. So you're saying, all right, if you contribute the bond, if you contribute an inheritance,
yep,
and create a bond with that, then it traces it as being from the death of a person and life insurance proceeds, and the income will be, if the beneficiary is a minor, accepted assessable income under 102 AE.
Yep.
If we are setting up a bond if a person, like if I've got a bond, I've got an investment bond, not one of these fancy scholarship education ones, just a plain investment
I should say
bond.
Traditional investment bonds are also, they're brilliant. I don't want to discredit them. They are also great tools. Yep.
Yeah. Okay. And so if I die, does the income, like it's been earning income this financial year, if I die, like from there on, does my death impact the classification of the income, or because it's already in the bond set up into Vivos, that's it? It
does, but I've got to get a tiny bit technical now. And it's the difference
between we don't have to derail you.
It's relatively, no, it's a good question. It's relative. I mean, it's inadvertently giving us a plug, and I know that wasn't your intention, but the way traditional investment bonds are designed is if the bond owner dies, normally the balance is paid out as a tax-free lump sum to a nominated beneficiary. Sometimes the bond owner dies, and instead of it paying out, the ownership transfers. So that's what would happen with a traditional investment bond. But with education bonds or scholarship plans, they're used a little bit differently. So massive general advice warning, because I'm not a financial advisor and I cannot provide Tara with financial advice. But if someone looked and was set up a lot like Tara and they held an education bond and they passed away, well, now you have a death benefit. But what we probably would have done as well is we would have nominated the beneficiaries not only as beneficiaries, but we also would have made them lives insured. And provided they're still alive, this investment can continue. So now you have a death benefit which remains invested for the benefit of these young children. And now we can be distributing the earnings to them to fund their education expenses, getting all those big tax credits along the way without creating adverse tax implications for them. And then when they turn 18 or 21 or 25 or 30 and all the education expenses are taken care of, we could be potentially maturing it to help them buy their first property. And that's the big thing. If you remember when I went back to the very start, is I was telling the story about the 4 grandkids above my grandfather's mantelpiece and what I was doing when I was 18 and what I would have used an inheritance for. We know 71% of grandparents like the idea of helping grandchildren. And the 2 main things they want to help with is education funding and housing affordability. And that's where an education bond can, in a more simplistic way, substitute a testamentary trust for those smaller amounts. The other one that Tara and I spoke with, I was working with another advisor. We had about $1 million, and I agreed. I said, no, you want to set up a testamentary trust. Like, it's worth setting up a testamentary trust for that amount of money. Unfortunately, the client passed away before the testamentary trust was established. So we then went and used the education bond as the alternative because we didn't have the trust already in place. Yeah. But yeah, Tara, back to your question. If it's an education bond and it's been structured correctly, when the bond owner passes away, we use the terminology, it shifts to testamentary status, which basically means you now have a death benefit which remains invested, and the earnings can be distributed to the nominated beneficiaries, and they will be taxed as adults. even if they're under age 18. Yeah.
Okay, so that's sort of going back. I should know this.
No,
It's revealing to everybody how little I know about my own investment structure.
I think this is why I love my job so much, because investment bonds were very popular in probably the 80s, and they've become more popular now. But particularly financial advisors are now starting to cotton on to education bonds, because they can pretty much do everything an investment bond does, but there's the additional flexibility and the additional tax benefits when used for estate planning purposes. We just have to make it clear to everyone that we are an education bond provider, and you shouldn't be using us if there is no intention to use your earnings to fund education expenses. Now, there's no penalty if you don't, but there should always be an intention to use the earnings for education. Now, if you've got parents, grandparents, or great parents investing for future generations, well, that intention is always going to be there. Well, for 71% of people, it's always going to be there. Yeah.
And Adam, I'm mindful of getting ahead of your presentation, but I've got a question. Camille's got a question about the mechanisms of, does the client or the bond owner nominate someone to make all the decisions about
you guys are doing
and manage the.
So for the rest of the audience, I promise people weren't set up to ask these questions, but they're asking the right questions at the right time.
Yeah.
You can still see the PowerPoint slide. Is that right?
Yes. We can see the education bonds second slide.
Oh, really? Yeah. Okay. We're behind in our slides then. So I've just clicked on a new slide and that hasn't shown up for you.
No. So do you want to stop sharing and reshare it maybe?
Yeah, I tried that a moment. Let me just try again.
Okay.
So I've stopped sharing, so you should be able to see the two of us, but I don't think you can. I think you're still looking at my slide.
No, I can still see it. Okay, I've got to turn screen share off. I'll press that button.
Yep.
Yeah, it's not doing anything though. Let me.
That's okay.
Can I share something? So I just shared that.
There's the Tax Act.
So I've turned it off. So do you want to try sharing again?
All right. So I'm still looking at your section of the Tax Act now.
Okay.
Let me just try something.
Guys, thank you so much for your patience. This is the first time trying this. If you were here last time, we did the Zoom meeting and we wanted to make it interactive, but I felt like it was unruly with such a big group of people. So we're trying this program, but so yeah, thanks as we work it through. So, all right, you can't.
No, that's look, and rather than
menu at all,
spend time trying to get this working, I can just use my hands.
Yeah.
So what I was going to show is a bit of a diagram that we've got in the slideshow. And the top of it says, look, you have a bond owner, and normally that's an individual or a couple. Occasionally it's a trust. So there are strategies where you might have a testamentary trust that's so large that it's distributing a huge amount of earnings, and that can't be tax effectively distributed. So what people do is they put a bond inside the trust, and it kind of acts as a sponge, meaning that it's still creating earnings, but those earnings are being taxed inside the bond at around 20 and 30%. And not ending up in a situation where they need to be distributed to any beneficiaries, right? But that's 99% of the time it's owned by an individual or it's owned by two people. Then you've got what's called a family bond. You can have up to 10 beneficiaries in our situation, and you have obviously those beneficiaries listed underneath it. But off to the side, we've got a role that you can nominate, which is called a bond guardian. Now, if you don't nominate a bond guardian, when the bond owner dies, the executor of your estate will manage the bond, right? But if you remember before, I said these things sit outside the estate. So maybe you want it separate. I can give you an example of that in a moment. But the most common example would be in my situation. I own my own bond, but if I was smarter, my bond would actually be owned by my father or my grandfather, all right? As horrible as it sounds, because they're more likely to pass away before I do, right? And if the bond owner passes away, well, now I get all these additional tax benefits for the kids, right? But I don't want to go down that path. But let's say it was owned by my grandfather and he passed away. Well, you now have a death benefit invested for my three children, and I could be nominated as the guardian, which means, I step in and I manage this money in their best interest, right? It never becomes my asset, right? I'm simply managing it much like an executor of an estate would manage an estate. Now, where that's really important is lots of grandparents have started hearing about this theory of die with zero, which basically means if you're going to give the kids an inheritance, give it to them when they're 40 or 50. Give it to them at a time when they're going to get more utility out of that money. But the main thing that actually, and I learned this firsthand by presenting to lots of grandparents and them telling us, one of their biggest concerns is, I don't want to give money to my kids when they're in their 40s and 50s, because if they separate, well, then half of that inheritance disappears. So what they can do instead is they can establish a bond in their own name, and then they can nominate their child. And if they pass away, then their child is basically managing this money for the grandchildren. So it's kind of working like a bloodline trust. So the parent theoretically can't make withdrawals for their own benefit, right? They must be managing it for their children. But I would suggest if they've got an investment and they can be distributing close to $20,000 a year to their grandchildren to take care of their education expenses and make capital withdrawals for holidays and stuff, well, there's probably some benefit in that for them anyway, right? Because that's $20,000 of after-tax income they don't have to find to pay those school fees. But going back to the original question, absolutely. If you're setting this up for estate planning purposes, you can nominate a bond guardian or bond guardians to step in and manage this investment for the beneficiaries if the bond owner dies or the bond owner loses capacity, in the same way you would an enduring power of attorney.
And Adam, with the beneficiaries being nominated, how much contingency planning is allowed there? Like if one of them predeceases, can you sort of nominate the next person to take their share? Or is it like, if you've got 3 kids, would you put 3 children in one, or would you do 3 separate bonds?
I normally advocate the family bond. And the reason for that is you have all your money in one area. And what that means is you might have a large, like if you have 3 bonds, then you can have the same amount of earnings, but split across 3 little bonds. Whereas if you've got all those earnings sitting in one pot, you might have one kid that goes to university, does a second degree, does their master's, and then does all this additional education. So you've got a larger pot of earnings that you can use for that beneficiary. And then the pot of contributions you could be using for the other beneficiaries. So having it all in one bond just gives you a little bit more discretion and a little bit more flexibility as to how you apportion the money. But the other thing, Tara, and I don't think you were meaning this, but I'll throw it in there anyway, is we've got 3 children. We don't call our 3rd child an oopsie, because that wouldn't be very nice. We refer to him as the blessing. But when we set up our bond, we had 2 kids. And then our little blessing came along, and we were able to add him as an additional beneficiary. So you can continue to add beneficiaries over time. And if they ever buy me a bad Father's Day present, I can remove them as a beneficiary as well. So the bond owner has ultimate flexibility as to whether or not they want to add or remove beneficiaries over time. Now, if they pass away and that guardian steps in, well, rules will have been provisioned by the owner as to what that guardian can and can't do. And normally, the guardian is trusted to add and remove beneficiaries as well.
Okay, and the guardian has that discretion within the beneficiaries.
Correct, yeah.
As to what their entitlements are. Yeah.
But it's very, very clear that the beneficiary must act in the best interest first of the education beneficiaries. And in the short amount of time we've got, I'll tell you another quick real-life case study that we discussed yesterday that I thought was really interesting. I'm not going to use made-up names. I'm just not going to use names at all because I'll confuse myself. But we had a situation where we had a grandparent that wanted to invest money for grandchildren, and they had 2 adult children. One they just did not trust at all with money, and one they very much trusted with money. And what was interesting is the one they didn't trust with money, they actually made the executor of their estate, which on paper looks really confusing. Now, that grandparent has passed away, and that child, as expected, is trying to work out what's in the estate and what they can get their hands on. And there's not much in the estate at the moment. There will be a refundable accommodation deposit coming through pretty soon. But what had happened in the months preceding that is 2 education bonds have been set up, which sit outside of the estate and are managed by the daughter. So the daughter is now managing these bonds where the grandchildren are now taxed as adults. So she can be using all of the earnings to fund all their education expenses right until the time they come 25 or 30, and then she can give them the balance to go and buy a house. I just thought that was a really interesting strategy because you had the son who kind of thought, oh, this is lovely, mum, trust me. She's made me the executor. And then upon her death, he's gone and done what we thought he would do. And now he's aware that there's some money off to the side that his sister's managing, but he's just like, oh, it's a small amount of money to help with the kids' education. He's not aware that there's quite a large amount of it sitting over there. So I just thought that was a really interesting strategy where they took advantage of the non-estate asset, they took advantage of the accepted income rulings, and they took advantage of that guardian role in a really interesting estate planning scenario.
Yeah. So one of the big use cases for a bond in estate planning is where we are concerned about a family provision application and we want to have non-estate assets that are not part of the challengeable pool available to satisfy a family provision application. So New South Wales, we've always got the notional estate disclaimer, which I assume notional estate could bring a bond in.
Yep.
Yeah, but in the other jurisdictions,
what happens there is they can't pull the money from the bond, but they have to equalise other parts of the asset,
yeah.
I should say.
Okay, well, actually, Roxley's gone straight in with the killer question. Does the 3-year lead time of setting it up avoid that, or are we in the realm of choosing to have the notional? Each year you choose the investment bond, so you never get the 3-year because your 3-year decision keeps getting reset
my
to
understanding
0.
is you kind of want to do it after you want to set it up 3 years pre-death.
Oh yeah, so the 3-year rule might apply to give you. Okay,
that's my understanding as of 12 months ago, from working with some advisors in Ballina that know you quite well, Tara. Again, I won't name names, but 12 months ago that was my understanding, and I haven't heard anything to have changed that.
Okay. So, I mean, in the TT Precedents Club, we are always workshopping scenarios about blended families and just trying to strike the balance of not making things too complex, but also creating a bit of certainty that a gift is going to ultimately go to the intended recipients, especially, if a testator just wants to make sure there is money there for their own children, but also providing, the bulk of the estate going to the surviving spouse. So an investment, or any kind of bond could be a technique or a strategy that we use to make sure that we've got a non-estate asset that's a pool of funds to go to those children and give that testator peace of mind.
Yeah. I've just clicked on something. I can't see you anymore, Tara. I don't know what that means for the rest of the audience.
We can still see you. It's all fine.
Yeah, I don't know if I can see you though. But
do you want to do like Alt Tab and see if that will bring up the?
No one in the audience. Like I apologize. I've just come back from holiday, so I'm a little bit rosy. So I apologize for anyone having to look at my face this big on their screen. But as long as they can see you and hear us.
Yeah, it's all like normal for us.
Okay, awesome,
yeah.
Great. Look, from a testamentary point of view, my standard line when working with advisors and estate planning specialists and accountants, I firmly believe testamentary trusts are the better tool. However, there are situations where the amount that you're looking to invest might not be sufficient, or there's just not enough complexity to need the testamentary trust, and that's where we can work really, really well. But what we're seeing more regularly is where you've got grandparents and great-grandparents that just want to carve a small amount out and leave it for the grandkids and see them being able to use it while they're alive, knowing that you've got all these protections around it, but also knowing that if they do pass away, this money remains protected and there's those additional testamentary benefits that do flow through. That's where we're seeing more and more people using us. It's grandparents and great-grandparents setting aside these early legacies. And then you've got this thing called Division 296 that some of the audience will know about. If that lands, that will be another interesting conversation for people with balances above $3 million, where they start going, okay, well, let's start thinking about our estate planning strategies.
Well, it's not quite Colleen's question, but I think it's the same principles behind it, because Colleen has said, back to your point where you said, well, ideally, like your father or grandfather would be setting up your bond because they might die first, and switch the bond into accepted assessable income mode. How does like their contributions into the bond or the income earned from the bond affect their Centrelink?
Yeah, very, very good question. That is the downside. So if I was to transfer my bond to my grandfather, I can do that without creating a capital gains tax event, but it then becomes his asset. Now, my grandfather is a self-funded retiree. He built a couple of factories in Melbourne and kind of just lives off the rental income. So he's not on Centrelink, so it wouldn't create an issue for him. But I've just transferred this money and it's now his asset. So, I mean, he's 96, so he's probably not going to. It's his money. He could run off and do whatever he wants with it. So there needs to be a bit of a trusting relationship there. But in answer to the question, you've got to understand the client's full situation before you go ahead and transfer it, because it will be treated as an asset. There is a strategy where you can put a bond inside a trust, and it will no longer be deemed for income testing purposes, but it's always asset tested.
Yeah. Colleen's got another great question, and I sort of had this too. There's a time, like you have to have the capital in the bond for a certain amount of time before you can release it. Is that true, or is that just some products?
No, not at all. So with traditional bonds, when you put money in, it all just sits in one account. So all of your contributions and all of your earnings sit in one account, and it builds over time. And when you withdraw that money, you always get some of your contributions and some of your earnings released at the same time.
Okay.
Now, if that is done in the first 10 years, you will pay tax on the earnings component that's coming out.
Okay, got it.
Whereas with the education bond, because your capital and earnings are isolated, at any point in time, you can just withdraw your contributions tax-free. Now, there's a misconception that when you make those capital withdrawals, they must be for education purposes, but they can be for any reason whatsoever. And the example I gave before is I made a $5,000 capital withdrawal to fund a family holiday to Wanaka, because my intention is to invest this capital to generate earnings, which I'm going to use for the kids' high school and university.
Okay. So that was my part of the question. Colleen's part of the question is the stipulated age. So, and you might have said this and I might not have listened properly. The bond owner can set a specific age, or is it just the eight? Colleen, are you referring to 18 and whether they're have the minor tax rate or the adult tax rate? Like, because she's wondering what if we've got children reaching the stipulated age at different points, like can we can release capital?
What I might do is I might try to answer the first part of it, because that
Oh, she's saying, if they stipulated 25 years as an age.
Yeah, perfect. Yeah. So it's in investment bond world, they refer to it as a vesting age.
Vesting age, okay.
Yeah, and there's products out there. One's referred to as child builder, and its biggest strength is its simplicity. And it's designed so that people can put a small amount of money away, and then that money will vest in the child's name at a given age in the future. And it's normally like 18 or 25. Now, there are other products out there that aren't as simple, which makes them more complex. I won't say better, because sometimes complexity doesn't always mean better, but there are some out there where you can choose any vesting date. You can say, I want this to transfer when they turn 40. Ours is set up so it can transfer on a given event. So you might say, I want it to transfer when my son or daughter gets married. I want it to transfer when they buy their first property. But some of the older style products are designed to vest on a particular age, and it's normally sort of 18 or 25. My belief, 18 years too young. More and more people that are doing this as a vesting strategy kind of starting to look at age 30 and above, because that's when people are maybe starting to settle down, have kids, get a mortgage, I think, I'll leave it at that. I think people know where I'm going with those comments.
Okay. So say there's the 3 children, the vesting age is 25.
Mm-hmm.
So do they just get like this a third once they each, or is it discretionary with the bond owner or the guardian as to how much they receive at that vesting age?
If you've used a family bond, which is what I normally talk to people about, it becomes discretionary. So you might set it up so that upon each child getting to a certain age, they receive $100,000 or they receive a third. Alternatively, what you can do is, instead of setting up a family bond, is you can set up individual bonds. So a bond for each child with a set vesting age. And we do see that. I know you get more value from a family bond, but I also know, like you go to my mum's place and under the kitchen bench, there's 6 of those old school money boxes, like with the notes wrapped around them. And she would know to a cent exactly how much is in each one of those money boxes, because she's been putting $2 a week away for each of her 6 grandchildren. I know if my mum was to set up a bond, she wouldn't want my 3 kids and my brother's 3 kids in their own pooled bonds. She would want each of them to have exactly what's sitting in those money boxes, because that's their entitlement and that's what she wants them to receive when they turn whatever age in the future. So it's a slightly longer answer to your question, but if you want to be black and white about what their entitlement is and what they'll get at a certain age, you do individual bonds. But if you do a family bond, you'll normally find each child will end up getting a little bit more. The guardian just needs to apply a bit of maths and discretion at certain times when that money is getting released.
Yeah. And Trisha has asked, can you nominate like backup or alternative guardians? Like, is there a succession capability for that role?
Yeah, so right now you can nominate multiple guardians. So you might nominate guardians of different ages, but that is absolutely something that we're working on, is giving the guardian the ability to cascade their guardianship. And the reason we're looking at that is, to be frank, when we launched this thing, we were very much looking at education funding before we realized some of the estate planning applications. And now we have people that are setting these things up to run like a bloodline trust, and they can go for up to 99 years. And so the guardian that takes it over in 5 years' time might not be here in 99 years' time. So we need to create the ability to cascade that guardianship. So right now, the only way to do it is to nominate multiple guardians, but in the not too distant future, we'll set it up so a guardian can nominate another guardian. Now, the bond owner can always instruct us to allow that, and we will do that. But as it's currently set up, if we haven't received that instruction from the bond owner, then a guardian cannot nominate another guardian. But there are ways to make that work in the short term.
Yeah. Now, I'm just mindful we're getting to the top of the hour. Anton has asked a question about how safe are the bonds? Are they guaranteed in any way? Well, do you want to just talk about that?
It's a good question. We get asked quite a lot. So they're safe in that they're protected from the estate and they're protected from creditors, but they're still market linked. So like we regularly get bonds for $1,000, but then we regularly get bonds for $1 million and $2 million. If you put $1 million into a bond and you invest it in the market and the market goes up, well, you're going to have more than $1 million. But if the market goes down, you're going to have less than $1 million. What you'll find, though, is most bond providers are relatively conservative with the investment options they let you choose. So we've got about a bit over 30 investment options, but the vast majority of money goes into what we call a diversified index option. And it's going to fluctuate, but over time it tends to go up, not down. But no, they're not capital protected. There is always investment risk. And again, that's where working with professionals like lawyers, accountants, and advisors is important, because the advisor will most likely sit down and work out what's your risk profile, how long are we investing for, should we be investing you in a balanced fund, or should we be looking at more of a high growth fund because we've got time to ride out this volatility. So in answer to your question, they're not capital protected. There is always market risk, but there is protection from creditors and there is protection from estate disputes.
Yeah. I might wrap it up there because we are on the top of the hour. Adam, you have just been so generous with your knowledge, and I feel like we've really just touched the surface, but this has been a great teaser and sort of introduction to the power of bonds as a concept. As I'm sitting here, I'm thinking, maybe we'll get you back next year to do a deep dive session for the lawyers in the TT Precedents Club membership, because we've got another question here from Colleen about like challenge risk for the beneficiaries of the bonds. And I've got a bit more question about, the capabilities of the different types of bonds and succession planning. I guess my highlights or key messages from today from the estate planning perspective is collaboration between the lawyer and the financial advisor, and then the bond provider is absolutely critical, because it sounds like there's multiple ways to structure these or different products available that achieve different outcomes and can, certainty, flexibility, longevity, short amounts of time. I love them as a tool in our toolkit for blended families, where we're on notice for family provision applications, for grandchildren wanting to set aside sums for grandparents setting aside sums for their grandchildren and having a little bit of control about how that's done. Circumstances where a testamentary trust is over the top, but we still want to have, some set away in a tax effective environment where we're separating control and the right to benefit. So I think it's a really underutilized tool in estate planning, and they are complex, but I think it's with anything that's complex, if you collaborate with the right professionals and the more you expose yourself to them, the easier they become. So I just want to say on behalf of everyone, thank you so much to you, Adam. Thank you to the audience for bearing with us with the tech problems, and Adam for just rolling with it. You did a great job.
I actually don't like PowerPoint presentations. That's probably worked out pretty well. And I'll just throw out there as well, like we've recently realized as well, a bond can somewhat replicate a testamentary trust. It can also replicate child maintenance trust. So we're starting to explore some strategies in that world as well. So that could be a conversation for a future date as well. But Tara, I appreciate you setting this up. And I really appreciate the questions being asked, because like I said at the start, I prefer to ask questions and keep this interactive than bore you with PowerPoint.
No, that's incredible. So we'll be sending out the replay for anyone who missed the beginning or wants to listen again. Adam, are you comfortable to share your slides with me, and I can put that in the replay?
I will, yeah.
So everyone's got that reference point as well. And yeah, I really appreciate everyone's feedback. We might have to get you back for a part 2 at some point, because it's a big topic. But thank you again, and thanks everyone for tuning in. We'll see you next time.
Thank you. See you, everyone.
Bye.